morning, everyone. Thanks so much for joining us today. This is I think it's our third Ask the Expert, which is focused on tariffs, Trump, and trade. There's a lot of uncertainty, and it's a complicated time as we all try and navigate through the threat of tariffs that the Trump administration is putting on. But we're going to be here with people a lot smarter than Greg to try and make sense of it. And we're very pleased today to be joined by Chris Andree, who is a partner at Gowlings WLG, to talk about employment issues that will naturally arise from the tariffs or the threat of tariffs. Chris is a member of the board of the Greater KW Chamber, but a partner, good partner of both of our chambers. I think has also was on, if I remember, several times during the COVID Ask the Expert. So now we've asked him to come on during the Tariffs Ask the Expert. So want to welcome him today and thank him for taking time out and readjusting his schedule to be with us this morning. Very helpful. Helpfully agreed to do a short presentation and then take some questions from us and you on the questions that you have around employment issues and tariffs. So Greg, without I don't know if you've got any comments. If not, we can get to Chris. He's going to do 10 or 15-minute presentation, and then we'll be able to open the mics and the chat and take your questions. So Chris, thanks so much for joining us, and over to you.
Great, thanks Ian, thanks Greg. I really appreciate the opportunity. It's always nice to go somewhere that calls you an expert. So because I don't get much of that at home, so I'm pretty excited to go anywhere where somebody will refer to me as an expert. So happy to participate. So
Chris, just one thing. Sorry, I should have done this off the top. If everyone could put your mics on mute while Chris is doing his presentation, so we don't get any background crossover noise, and then you can open up when we get to the Q&A section. So sorry for that, Chris. Back to you.
Sure. Okay. So the purpose of the presentation, or the outline of the presentation, really is to talk about the impact of the threatened tariffs on the workforce in Ontario. A lot of the comments that I will make will have application if you have operations in the other provinces in Canada, other than Quebec. It's obviously a little bit different, but in the other provinces, a lot of this will also apply. But I don't practice in those other provinces, so you have to sort of get local counsel, which luckily we can provide in several other provinces. But and in Quebec, things can be very, very different. And so if you have part of your workforce in Quebec, you need to seek local counsel. Again, we could help you if you needed that. Really, what I want to talk about is some of the things that I want every business to know when they are considering what to do in response to either the threat of tariffs or the imposition of those tariffs whenever they may come. And this presentation, at least in part, was driven by the fact that the tariffs were threatened to be imposed next week. Based on the last couple of days, it sounds like perhaps they won't be. They might be. Could be tomorrow, based on sort of the rather moving target. But the upshot is, what I want people to understand is they need to be thoughtful and deliberate and dispassionate to the degree that they can be in making the decisions. And where a lot of this comes from is the reaction that we saw to COVID. When COVID finally made its way, even though everybody knew that something was coming, of course, nobody anticipated that it was going to be as impactful as it was. And what businesses tended to do when the shutdown came was they reacted in a knee-jerk way, and many of them made decisions which made perfect sense from a business perspective, but were significantly negatively impactful from a legal perspective in relation to their relationships with their employees. And so what I wanted to do through this presentation is to make sure that everybody is aware of the legal framework and the risks of taking those sort of unplanned or knee-jerk reactions, because in many ways, what we found with some of our clients and with others in the community, in the business community, was that the decisions they made, the actions they took, were in some ways worse than the impact of the pandemic on them it would have been had they not taken those actions. And I'll talk a little bit about what it is that I'm referring to. So the first thing that you need to do when you're talking about the impact of the tariffs and the reaction you may have to it is, what do you have the right to do? And I want to pause there, and I want to say, I don't criticize the businesses for making the decisions they made and imposing the changes that they made. The most obvious changes that we saw were temporary layoffs of workers, excuse me, and reductions in hours, or for salaried employees, reductions in pay. So we saw businesses temporarily lay off some, and in some cases, a substantial component of their total business workforce. And then in other cases, we saw businesses who were cutting hours dramatically, the consequence of which is you're cutting the pay of those employees if they're hourly paid, or with salaried employees, reducing the salaries by 10%, 20%, 30%. And we saw those kinds of reductions. We saw people suffering a 30% reduction in their compensation overnight. And what many businesses were doing was saying, well, we're laying off all the people in this area of our business, or we are reducing the salaries of everybody across the board. And in some cases, what they were doing was they were saying, at the lower levels of the organization, it's a 10% cut. In the mid-level, it was a 20% cut. And at the higher levels, it was a 30% cut in salary. Those were the kinds of reactions that we saw. And those decisions had significant legal consequences down the road. So let's start with, what is the legal right to make the kinds of changes that I'm talking about? The foundation is the employment relationship is a contract. I deal primarily with non-unionized businesses. I have colleagues who deal with unionized businesses. The relationship where you're non-unionized is you have a direct contractual relationship with the individual employee. In a unionized environment, you have a collective agreement with the workforce that is covered by that union certificate. And so, but in both cases, they are a contract. And you've all entered into contracts. You may have entered into one this morning when you bought your coffee or your bagel, or whatever else it is that you may have done. You may have done a renovation to your kitchen. That's a contract. You may have done snow removal. If you're probably getting a good deal this year on the snow removal contract. But the fundamental basis of the contract is neither party can unilaterally change the terms. That's the fundamental premise of a contract. And so when you as a business want to make a change, if you do so unilaterally, it doesn't matter from a legal perspective why you made that change. If you are making a unilateral change, you are breaching the contract. And so fundamentally, unless you've got a written employment agreement with that employee, and I'll talk about ways that you may be able to gain that right to make these kinds of changes, but unless you have a specific agreement with those employees, when you make the kinds of dramatic changes that I have described, you are breaching the contract. And so the consequence of that breach can be something called constructive dismissal. I suspect everybody on this call has at least heard that phrase or that concept, but probably doesn't know the detail of it. So I'll explain what it is. What a constructive dismissal is where one party, typically the employer, makes a unilateral and substantial change to a fundamental term of the employment relationship. So first concept is unilateral. You don't get their consent, you don't get their agreement, you just make the change. That's a unilateral change. The second piece is a substantial change. So if you change the process for, applying for vacation approvals, that's not a substantial change. If you change somebody's compensation by 20%, that's a substantial change. And the third piece is a fundamental term. So fundamental term, their duties, their responsibilities, their compensation, their benefits. Those are things that one would typically consider to be fundamental. And so those are the kinds of things that we are talking about, which can trigger a constructive dismissal. If it is the employee takes the position that they have been constructively dismissed in response to the change that you have made, their right is to resign and sue for wrongful dismissal. Now, you would be familiar with the general concept. If an employee voluntarily resigns from their employment, they're not entitled to notice, they're not entitled to severance. They resign, they give you the date, they leave, that's the end of their entitlement. In a constructive dismissal, they resign, but the legal position they are taking is, I am resigning in response to the unilateral change that you made. You have shown me that you no longer feel bound by the contract that we had, the contract of employment. And so my reaction to that is to resign and say, okay, I accept that you no longer feel bound, so I'm going to quit, but I have the right to sue you for wrongful dismissal. In the same way as if you as the employer had walked up to them and said, you're fired today. By making the change from a legal perspective, what you've effectively done is you've said, I'm terminating your employment. In this context, you're saying, I'm terminating your employment under the former terms, the old terms, which may be that you are making 20% more, and I'm offering to continue the employment on these new terms, 20% less, but you as the employee have the right to say, no, I don't accept that. And so I'm going to resign and I'm going to sue for wrongful dismissal. And everybody on this call would have some concept of what the consequence is of a wrongful dismissal lawsuit, right? There's a claim for notice, there's a claim for severance, there's a claim for other entitlements. So what are the strategies that you might employ when you are responding to the threat of tariffs or the actual imposition of those tariffs? You may or may not be aware of the work-share program. The work-share program is under employment insurance. And high-level general concept is, if you as an employer have suffered a substantial negative change in your business, and the employees have suffered a lowering of their income as a result of that change, you may be eligible for an application to the work-share program. And effectively what that program does is it allows you to continue the employment of the employees for a number of days, and you make the application based on how many days in the week you want them to work, and you would pay them for the work that they do on those days. And then for the other days, when you can't afford or can't continue to pay them their regular wages, they qualify for EI benefits. So an example would be, you need to go to a 3-day work week, you pay them for 3 days, they collect EI for 2 days. That is different than the normal EI program, where if they were to have any work or any income during a time when they're collecting EI benefits, those EI benefits would be clawed back because they had replaced them with income from employment. Under the work-share program, they don't claw back the amounts that are earned. A second strategy you may have is government relief. We saw all sorts of that during COVID. There's nothing that has been announced to deal with any sort of government relief for businesses that are suffering the consequence of the current threat of tariffs, even though many businesses are suffering a consequence as a result of that threat. There is no government relief that has yet been announced. We may see that if the tariffs come in. I highly doubt we will see that if they don't actually come in, but we live in this world of threatened tariffs month over month over month. Other strategies are the proactive reduction in hours or compensation. I talked about that earlier. And, you know, how much of a reduction would there be? How much would you save? Those are the kinds of things that you might be engaged in. Another strategy is temporary layoffs. I talked a little bit about that. So let me explain how that proactive reduction in hours and compensation can amount to a constructive dismissal, a substantial change to a fundamental term. No question that if you went from a 5-day work week to a 4-day work week, that's a 20% reduction in the hours. If you went from 100% salary to 80% salary, that's a 20% reduction in income. No question, that's a constructive dismissal. There's some case law out there that talks about if you don't reduce the compensation by more than 10%, there's sort of this perception that if the change you make is only a 10% change, that's not likely to be a constructive dismissal. Because while it is a significant change and it is unilateral, it is not substantial enough to constitute a constructive dismissal. There's no case law that says 10% is the number. If you stay below 10, you're okay. If you go above 10%, you're not okay. There's no case law to that effect. The other thing that you want to recognize is, and we saw this during COVID, is we're going to impose a 25% reduction in hours or a reduction in compensation, but it's only going to be for 3 months. Well, the effect of that is a 7.5% annual reduction, which is below that 10% threshold. But if you tried to, you know, pay your mortgage and pay your car loan and buy your groceries and pay for your kids' activities and, you know, et cetera, on 25% less than you were making on the last pay period, there's no question the court's going to find that to be a constructive dismissal. So, you know, that 10% threshold is not something that people should build their strategy on. It's a useful guideline that may have some impact, but it should not be the decision or a key part of the decision. Temporary layoffs. The one thing that I really want to stress to people is there is no automatic right to lay off. Anybody who has any familiarity with the Employment Standards Act in Ontario will know that there are layoff provisions in that act. And they talk about if there's a temporary layoff for, you know, less than 13 weeks in a period, or less than 35 weeks in a 52-week period, if you continue the benefits, you can lay somebody off. There's a bunch of case law that is very clear that those rules in the Employment Standards Act do not create the right to lay off employees. They govern how you can lay off employees, but they do not create that right. If you have not, through a written agreement, through a policy, etc., created the right to lay off, immediately upon you implementing the temporary layoff, there are going to be some people who will or can take the position of constructive dismissal. Because what you have effectively done is you have reduced their income by 100%. I talked a few moments ago about a 10% threshold being perhaps, well, you've done it by 100%. And so there's no question that if you do not have the express right to lay off, that will be considered a constructive dismissal. And there's lots of cases out there that talk about that. So the thing you need to do is you need to assess the risk of constructive dismissal. And you need to look at your written employment agreements with your employees. And I've talked a lot about, I want to say this, I've talked a lot about the contract of employment and breaching the contract. And I'm not talking about a written contract. The relationship between the employer and the employee is a contract, whether it's written or unwritten. And so when I talk about the contract and a breach of the contract, I'm talking about a breach of that relationship. I hope you have a written employment agreement. If you don't, you should be implementing those going forward. But you need to check that agreement. You need to check your policies. You need to assess the practices that you have had in your business. For example, have you laid that employee off, that very employee off in the past? Well, that would suggest that you have that right, but you need to assess that risk. You cannot make any assumptions. I talked about how much is too much. I talked about that 10% threshold. How likely is a claim? Most employees don't sue their existing employer. Not a good strategy, generally speaking. So I would say that the vast majority of employees who are temporarily laid off or have a reduction imposed on them will accept that change reluctantly, perhaps angrily, but they'll accept it. They won't resign and make a claim for constructive dismissal because they want to come back. They want to continue their employment. So who's the most likely to make a claim? The most likely people are the ones who are dissatisfied with their job already. They're going to take this as the opportunity now to quit and make a claim, whereas if they quit before the change, it would be a voluntary resignation and they'd be entitled to nothing. So those are the people. The other people are, we see typically, are people who are long service employees, older workers who are nearing the end of their career. And they're saying, okay, this is my chance to get out and take a package or get a package. And if they won't offer me one, here's a way for me to demand one. And so those are the people who are, in our experience, the most likely to make a claim. The other thing about them, they are the most expensive because longer service workers, older workers, are the ones who tend to be awarded more notice of termination or pay in lieu of notice under in the common law or in those wrongful dismissal cases. So what's the potential value of a claim? The real math is everybody will owe employees something under the Employment Standards Act, or if you are a federally regulated employer, under the Canada Labor Code. There's a mathematical amount that you owe. I'm assuming most of the businesses on here are smaller employers, so perhaps they do not owe statutory severance pay. Statutory severance pay is if you have an annual payroll in excess of 2.5 million globally, and the employee has 5 or more years of service, they are entitled to statutory severance pay, which is something different than the notice pay or termination pay. If you don't have a written contract that manages their liability on termination, then you have a common law liability. So that's where you hear concepts of pay in lieu of notice, common law, wrongful dismissal damages. Those numbers can be up to 24 months pay, less what they earn during that time. But if you're dealing with that older, longer service worker, you impose a layoff, you didn't have the right, they take the position of constructive dismissal and make a claim. It's generally recognized older workers have a harder time finding replacement employment. They're probably among your more expensive workers because they've gotten raises year over year over year. And so the potential value of a claim is 24 months pay to that individual. You lay off 10 of those individuals, it's 24 months times 10. You were trying to save, some money by doing this layoff or by reducing their compensation by 10% or 20%. Instead of that being the result, you now owe a whole bunch of people a whole bunch of money. And so that is the kind of catastrophic result that we are trying to help employers avoid. Okay, so that is the consequence of a failure to assess the risk. Right? I talked about statutory notice. I talked about statutory severance. Mass termination. If you terminate the employment of 50 or more employees in a 4-week period, it triggers a mass termination obligation. There's more notice. You have to notify the Ministry of Labor. There are all sorts of other obligations. I'm assuming that most of the folks on this call are smaller employers and are not likely going to trigger those obligations, but I wanted to highlight them for you. A couple of other risk points. You may have some fixed term contracts on your books. So you've said to somebody, I'm employing you for a year, I'm employing you for 2 years. Those people are among your highest risks. So for those people, I'm going to assume that you have a written agreement because that's typical. There are lots of cases recently where the early termination provisions in those contracts, and please tell me you have such a thing, the early termination provisions in those contracts are unenforceable. the courts have said, the termination provision violates the Employment Standards Act or is ambiguous or is somehow otherwise not enforceable. And the consequence of that is, and the decisions are clear, you owe the employee the balance of the contract. And even if they find another job during that period, there's no reduction. So if you were to terminate someone who has 18 months left on their 2-year contract, you would owe them 18 months pay. That is catastrophic. Another group that you need to be conscious of are temporary foreign workers. Typically, for those of you who use TFWs, you would know that the work permit is typically tied to a specific employer. Well, if you terminate that individual's employment, they can't go out and find replacement employment without going through a process to get a new work permit specific to that new employer. That creates barriers for them to find replacement employment. The consequence of that is the court is likely going to award them more notice than the same employee in the same position for the same period of time who is not a temporary foreign worker. And the last group I want you to be aware of are independent contractors. These are folks that many businesses will think, well, that's the first group that I can impose changes on or end the relationships with because I don't owe them anything. That's the whole sort of concept behind independent contractors. Well, that's often not the case. Independent contractors are often found to be dependent contractors. And the courts have been very clear that they get the same notice as an employee. There are true independent contractors, but much of the time where you're dealing with individuals, they can be found to be dependent contractors, and then you still have an obligation to provide them with notice. So I want you to be aware of that group as well. So here are the takeaways. Please make informed decision. Understand your rights and, more importantly, your obligations, and plan for the financial implications of these actions. Recognize that you may owe somebody 24 months pay. Well, you need to plan for that. Every business would. If you've got 10 people in that same category, can you plan for that? Be strategic, be knowledgeable, be deliberate. Don't be rash and unplanned. So that's all I have to say, Greg and Ian. I'm sorry I went on beyond the 10 minutes that you told me to.
No, that's fine. That's great information, actually. Not just for tense situations that we're in, like we are right now. But, I remember back, Chris, during COVID, the government actually came out and put temporary changes to the Employment Standards Act, or gave provision for extended layoff periods because it was going to go beyond the 35 weeks or whatever the case may be. Of course, we haven't heard anything about that at this point because this is a moving target, I guess, in anybody's mind. But I think what employers need to understand is many of those changes that happened to allow employers to have a little bit more flexibility during that period of time, they are not in place now. So you can't rely back on those circumstances and assume that they're going to be there forever.
And I would say, I would add to that, Greg, I'm not expecting that they will be put in place. And the reason for that is COVID affected everybody, right? If you didn't need the help, you didn't have to take the help, but COVID affected everybody. This is not going to affect everybody directly, right? This is going to affect those businesses that are selling physical products into the US. That's who it's going to affect. Well, there's lots of parts of our economy that do not sell physical products into the US. There are lots of parts of our economy that are impacted by, the economic activity generated by the people who sell products into the US. But it's not going to cut across the entire, sort of business community as it did with COVID. And so, I'm not as optimistic that the government can be as precise in its sort of support of businesses that it would need to be to provide that kind of legislative support to employers, because you can't just say every manufacturer. Well, there's lots of manufacturers that don't sell into the U.S. I mean, there's a high proportion that do, but not everyone does. And so the government will not want to give those kinds of relief to employers and businesses that don't need it, because it negatively impacts employees, right? It's ironic that today's election day, right? And, this government has been trying very hard to put itself in a favored light amongst working people and unions and that kind of thing. And you can come to your own conclusions about whether they have or haven't, but they've certainly tried. And I'm not convinced that they're going to want to risk whatever momentum it is that they have, assuming they win the election. And I'm not a predictor, but I have, every radio station seems to think that they're going to win. Assuming that they continue to be the government, I'm not at all convinced that they're going to implement the kinds of supports to employers that would be needed to offset these risks that I've been talking about, because they would need to be very planned and very targeted. And I'm just not sure that legislation is capable of doing that. It's a pretty blunt instrument.
And I think when we think back to COVID, I mean, as much as we say the programs were broad and everyone had access to them, that wasn't actually the case, and that was as targeted as you could get. There were some companies and small businesses that weren't covered by it. And so I take your point, and it would be very hard to be precise with a government program to get who you want to get at. But I want to go back to the work share program, because I think that trying to figure out, and I think the advice, and when we talked earlier in the week, which resonated with me, is try not to do something rash that, as you've laid out, that could have real world implications for your bottom line, and then for when things settle out, and they will eventually settle out in some fashion in this new environment. Are you hamstringing yourself from ramping your business back up? But the work share program, is that the type of thing where they could beef up a specific program to say, hey, look, we know at least for a temporary 6 months or 12 months, we may increase the either the funds available or the capacity of a program like that? Like before you get to layoffs, is that the sort of thing that you should really strongly look at, that type of program which can mitigate the impact to the cost of your business?
Absolutely. That's the kind of thing that it's already in place. So the process is there. The path is well worn. They don't have to sort of reconsider anything. It's a known program. That's a federal program because of DI benefits, right? So the province wouldn't have anything to do with that. But I do think that every business that is considering having to cut back, whether it's cut back in their production because they're just not going to be selling as much stuff, or they've built up their inventory and now they're sort of waiting to see how it plays out, or whatever it may be, those are the kinds of programs that are already in place that they should be considering first. Because what we saw in COVID was, I'm going to temporarily lay off people. I'm going to sort of see how this all plays out. Nobody expected it to last as long as it did. And it was sort of, okay, I'll put these people on the bench for 3 months or whatever it is, 13 weeks. And then hopefully I'll be able to recall them and on we march. Well, the consequence of the kinds of actions that I'm talking about is you may think that all your skaters are on that bench. The problem is some of them are going to opt out. Some of them are going to say, I don't accept this change. And so where you thought you had a full workforce ready to come back when it was time and you needed them, you're not going to have them. And you may lose some of your most skilled and experienced. And, that's what we saw was it was those longer service, older workers that were not as motivated to stay in the business for whatever reasons. And so, you cannot assume you're dealing with people. You're not dealing with machines. You can turn off the power to the machine and it'll still be there when you turn the power back on. People are going to react to every action you take. Don't assume that you know what their reaction will be.
Okay, any questions from those who are listening in? Just Lauren.
Hello, I just had a question about the independent contractors and I guess what the I guess the ranking would be in terms of contracts. So say they have their own like kind of employment contracts, usually an independent contractor is not going to sign something like that. Say an independent contractor has their own contract that they enter into with the business owner or the decision maker. And then of course you have the ESA that you mentioned. What's the priority ranking of those types of contracts in terms of like what gets adhered to or what gets kind of held up if anything were to go to court?
Okay, there's a bit to unpack there. So the independent contractor and employee, those are two solitudes. You are either an independent contractor or you are an employee. If you are an independent contractor, you are not subject to the Employment Standards Act. It only applies to employees. If you are an employee, you are subject to the Employment Standards Act. The challenge in this sort of dichotomy is the courts several years ago created a third category right in the middle. The third category is you are not an employee, so you don't have the entitlements of the Employment Standards Act, but we recognize how dependent you are on this business that you are providing services to. And so in response to the impact of ending the relationship, we are going to find you to be a dependent contractor, and therefore we're going to award you, the court is going to award you, it's often same or at least similar kinds of notice to what an employee would be entitled to. The way that you address all three of these sort of groups and your liability to those groups is through a written agreement. So you'd have an independent contractor agreement with the independent contractor. It would probably be the same agreement with the dependent contractor. And then you would have employment agreements with your employees. And so if the matter were to go forward, so the independent contractor, what usually happens in the independent contractor scenario is they are happy to be an independent contractor right up until it doesn't suit their purpose anymore. That's when there is a magical transformation and they now want to be considered to be an employee. Because as an independent contractor, they're not eligible for EI benefits. They're typically not eligible for WSIB benefits if they were to be injured. They're not entitled to notice of termination in theory, although we've got that dependent contractor issue. So it's when you end the relationship with them that they all of a sudden say, oh, no, I was always an employee. Yes, I know I filed my tax returns as an independent contractor. Yes, I know I issued invoices, but I was always an employee. So now I want all the benefits of being an employee, which includes the rights under the Employment Standards Act, et cetera, et cetera. And
Chris,
so, yeah.
Well, yeah, no, I just want to follow up, which is very helpful. I kind of missed that there was that middle category. And so maybe for people listening here, we're kind of in this no man's land of, are the tariffs coming in or not? And you've highlighted until something like that happens, make your plan. I guess the question comes up, you've got these three categories, and if you don't have these employment contracts for independent contractors or the dependent contractors, if you do it now, does it still hold weight? Like if you don't have them in place, is now the time to make sure they get in place? Because I guess the other part of the Trump tariffs issue is this is not going to be a 3-month thing or 6-month thing. This is likely to be a 4-year run of ups and downs and what's he going to threaten next and potentially put in place. So if you don't have those things in place so that you know exactly what the parameters are of your specific company's situation, does it still pass muster, and is it a good thing to do now if you don't have it already in place?
Yeah, yes, it's never, what's the saying? It's never the wrong time to do the right thing or whatever it is. But but what I caution people with is sometimes they will generate a document, and please, I'm going to do a pitch for every lawyer. Please don't use the online stuff that you find and print it off and get your employees to sign it. It's just not, you need more. You can't simply, call the employee in or walk into their office or whatever the working arrangement is and say, I need you to sign this new agreement. They may very well sign it because they either are told or they get the distinct impression that if they don't sign it, the relationship is going to end immediately or soon thereafter. So they will often sign it. The problem will be when the employer sometime down the road goes to rely on that agreement, it is almost assured that that agreement is unenforceable. And the reason it is unenforceable is not because the language wasn't correct, even though it may be if you haven't used a suitable form. But the real reason it's unenforceable is because, I'll go back to my first slide, and the relationship is a contract. In order for you to enter into a contract, there has to be, and this is first year law school stuff, offer, acceptance, and something called consideration. Consideration is a fancy word for value. Each party gets something of value. Where in this scenario of walking into someone's office or calling them in and getting them to sign, you've received value because you now have an agreement. They have received nothing of value. In fact, they've given away existing rights that they had. Perhaps they had the right to notice of termination, and now the agreement says they don't have any rights, or they've reduced those rights. And so when you go to rely on it, it's unreliable. And that is in many cases worse than not having an agreement at all, because you put stock in that agreement, you rely on it. The planning I'm encouraging you to do is to plan and know what your rights are. You look at the agreement, it looks like you have some rights, but you don't.
Mhm.
And you don't, not because of the language, but because of the process.
Mhm.
Mhm. Yeah, it's and I'm going to look to if there's any other questions as well. But where we see where we lie right now with everything is a March 4th, I think, date. Is there was some confusion yesterday where the president of the United States said that it's going to be April 2nd. What he has done is he took the March 12th, added 25% on steel and aluminum. He moved that to April the 2nd. The Secretary of Commerce came out and corrected the president, a little while later and said, no, the initial tariffs are going in. However, he did say that the initial tariffs are going in on March the 1st, subject to evidence from either Mexico or Canada or both that the standards of which these tariffs are being imposed have been addressed. So border security, reduction of fentanyl going across the border and people. However, everything is, it's so up in the air. Nobody really, kind of knows what is going on inside his mind, and he seems to be just blurting things out whenever he wants to. The real problem is of course, business requires certainty, and there is no certainty in the air right now, especially if you're doing business in the United States. So you have to be on your toes, and there's all kinds of things. And I think, Chris has highlighted today, there's certainly things if you're one of those directly impacted businesses, or even, you're going to be impacted because suppliers or customers that you work with are going to be impacted. You need to understand where your legal rights are and where your employees' legal rights are. This is a really big deal, and I think, as Chris rightly pointed out, the probably the government support services aren't going to be there like they were with COVID. That's for sure. And we're going to have to wait and see what those are. What Donald Trump has said is that if Canada puts in reciprocal tariffs on items, that he will, increase the this could be a ping pong game for who knows how long. And we're, I think our best Waterloo team is rightly concerned that if this goes on for the full 4 years of the Donald Trump term, we're going to have uncertain times for 4 years, and that's not really good news for the business community. And we have to sharpen our pencils and do some things to figure this out and navigate through this in the next short period of time as quickly as we possibly can.
I want to do, I'm going to do an advertisement for all the lawyers out there, but I'm also going to do an advertisement for the accountants out there. And that is, please get together with your trusted legal advisors, your trusted accounting advisors, and talk about how they can help you. Yes, it's going to cost you some money, and it may cost you more than, feels comfortable at the moment. But I can, this is the kind of thing that can be, and I saw it with clients. I've talked to clients in the last 2 months. This could be the kind of thing that is, catastrophic for businesses. It is, they talk about bet the company litigation. This is the kind of thing that could be for some businesses, bet the company steps that you take, actions that you impose, and decisions you make. Please get some informed advice, not advice that is secondhand through somebody who's in your industry that already got some advice. That's not the advice you need. You need the specific advice for your specific business. You need to ask the kind of questions that you want to ask. You need to get good, tailored, bespoke advice for your business. And, crossing your fingers is not a plan. And that's what a lot of businesses seem to be doing right now. And, you saw in the last 2 days, like the guy just doesn't seem, this reminds me of when my kids were little. I got 3 kids. How clean is your room? You can't do anything until you clean up your room. Well, how clean is clean? And that's where we are, is, how much fentanyl has to be stopped? How secure does the border need to be? It is about as precise as, clean up your room or you can't do whatever it was.
Chris, this kind of raises the issue. I mean, we've seen a lot, and I frankly don't think it should stop. If we avoid the tariffs for another 30 days, which is trying to source from Canada. So you're not, are there other partners that you might get source your products from or your inputs from to try and get away from having to cross the border in the first place? But it raises the question of if that, it relates back to labor in this way, is if you change your business model, and this consequence has that it sort of changes the relationship or the work that an employee is doing, because there's a different partner, there may be a different process that gets put in place. Does that fall into this category, or is that, geez, we have to go to a new supplier, and therefore, like, it maybe, no, you can't work at 80 Queen Street North, you have to go to Greg's office in Cambridge? That would be that's a change. It's a reasonable one.
I get your points. I get your points, Ian. I think what you're talking about sort of broadly are changes in terms and conditions of employment. I've talked about layoff, which has a direct financial impact, compensation adjustments with a direct financial impact. What you're talking about is other terms and conditions that change, the location of the business, for example. Yes. Depending on how substantial the change, then it can be a constructive dismissal. I think those kinds of changes are going to come more slowly. I think you used to deal with this supplier with whom you had a good relationship, and now I'm telling you need to deal with this supplier whom you don't yet know, and you're going to have to develop a relationship. No, that's not going to be a constructive dismissal. If you used to have to drive 150 kilometers to pick up whatever it was that we needed for the production process, and now you have to drive 175 kilometers. No. But if you used to have to drive from Cambridge to Waterloo to pick that up, and now you need to drive from Cambridge to London to pick that up, that's a bigger change, especially in the winter when driving conditions can be, substantial. There are all sorts of changes that can have that impact. What we found was, and I think rightly so, courts were a little bit more flexible during COVID than perhaps they would have been absent COVID with making some of those sort of kinds of changes. They weren't forgiving if you change compensation, but they may be a little more forgiving when you're changing those kinds of terms. But, we'll have to see where all of this comes. But if you are making dramatic changes in your business, I think you always have to, absent tariffs, absent COVID, if you're making those substantial changes, you need to think about what's the impact on our employees and what is the legal consequence of making those changes. Every time.
Yeah.
As everyone maybe recalls, if you were on the call last week, we're working on getting Flavio Volpe from the Automotive Parts Manufacturers Association of Canada. He is also on the Prime Minister's Canada-US Council. Very busy guy. We couldn't get him on this week, and I think the reason was he is in meetings this week pending next week's proposed tariffs coming in, but he wanted to wait until we got by that March 4th date anyway. So I think he'll be on next week, hopefully, next Thursday from 9 till 10 a.m. And hopefully be able to bring us up to date as to what's going on and when reciprocal trade tariffs will be implemented, but also what impact this is going to have certainly on the automotive and related industries as well in Ontario. He suggested back when Ian and I had him as a guest here and did our radio show at live in front of some chamber members. He suggested at that point that the impact to manufacturers or assembly plants was going to be, within 4 or 5 days. That's when you'll see supply chains kind of jerking a bit and causing some problems, but also it will impact the end user, the consumer. Prices will start to rise immediately to accommodate for future builds of the vehicles, and I think we're going to see some impact. That's if this all goes in. We've been threatened this before, and at the 11th hour, it was taken away. I think the federal government is working very, very hard to try and mitigate any implementation at all, but you never know.
Greg,
there is a question here. Will there be a separate invite link or a Zoom link working for the next meeting as well? All you have to do is, you can just register on chambercheck.ca. I'm not quite sure. I haven't really studied the links to see if they're exactly the same every week, but all of the weeks ahead are actually, I think, there's several weeks ahead anyway, are already on the Chamber Check site. But it doesn't hurt to register. We like to know how many people are coming anyway into the meeting room so that we can make sure we have enough individuals behind the scenes to control for questions and bringing people in. So,
and just as we wrap up, I think it is helpful for us to know how many are coming on. I do want to thank Chris for making time, and I know he had to juggle his schedule to accommodate us because we're doing this in real time. And after we were at a board meeting together, and his comments around the issues around labor, which I hadn't frankly thought about some of the specifics, very helpful information. We'll make sure that this is posted in chambercheck.ca. So if you've got friends or colleagues who didn't get the opportunity to see this, they'll be able to access this in the next day or so when we post that to chambercheck.ca. And that's, again, Greg, where all the information we get from our trusted partners, whether it's lawyers, accountants, BDC, government programs or information, is where it can be. But thank you to Chris for taking time out of your busy schedule and joining us. Gowling's always is more than willing to step in when either of our chambers look for support, and we appreciate your time today.
No worries. And, please, you can see my email address there. If you go to that website, we actually have a page that's all about tariffs and trade issues and et cetera. So a lot more than just sort of the labor side, workforce side. So I would encourage everybody to visit there. It also has links to, government information, U.S. law firms who are giving sort of their perspective, et cetera. So there's lots of good information on there. So I would encourage you to go there as well.
Awesome. Thanks very
Okay.
much, folks. Hopefully we'll see you next week.
Okay,
Take
thanks,
care.
gang. Good stuff.
Bye-bye.